This is Centerville Mobile Home Park versus Craig Kloppenstein and Gretchen Anderson. Mr. Daniel Landman is here for the plaintiff. One of the owners of the park, Christy DeCenzo, is here, and Meg Bauer is here from Legal Aid. Both Mr. Kloppenstein and Ms. Anderson are on the lease, but I think, does she reside there or she's just on the lease?
She's just on the lease as a co-signer.
All right.
She's actually over in Courtroom's rehab over in 3 Rivers. She spent 2 months up at Borges and she's over at rehab now.
All right, well, this is filed as a termination of tenancy action. We were here previously on March 16th. They allege a number of matters: disturbing the neighbors, cats.
The courtroom opens with a tense legal dispute between Centerville Mobile Home Park and its tenants, Craig Kloppenstein and Gretchen Anderson. While Anderson is only a co-signer and currently in rehab, the focus quickly shifts to Craig, who is actively living on the property. The presence of legal representatives on both sides signals that this is not a simple disagreement, but a case heading toward a serious legal battle.
Overall appearance of the unit, loud music, other things, and they wish the defendant to move. And the matter was filed. Meg Bauer filed an appearance on behalf of the defendants. What I set this for today for 45 minutes, thinking that's going to take us a while, but we're probably going to have to set a trial on this, I would imagine. Mr. Landman, let me start with you. What do you know about the current status?
Your Honor, here's what I can tell you. I think the court is absolutely correct as far as the need to schedule a trial date. While I have not received any kind of formal answer from Ms. Bauer, she did verbally deny the allegations last week, or at least indicated that she did not believe, based on her review of the matter, that there was a sufficient ground for termination. We obviously disagree.
This case revolves around a termination of tenancy filed by the park owners. The landlord alleges multiple violations, including disturbing neighbors, poor property conditions, loud music, and issues related to animals. The court had already heard parts of this matter earlier, but now it's becoming clear that a full trial may be necessary to uncover the truth.
Since last week, it is my understanding that Ms. Bauer served a FOIA request on the Constantine Police Department. We became aware of it because the Constantine Police Department turned around and reached out to my client, trying to get some information that Ms. Bauer had requested in the FOIA request that the Constantine Police did not possess. And to the best of my knowledge, we cooperated with the police's request. I don't know if they have made any type of disclosure to Ms. Bauer. I did not get a copy of either the FOIA request or any response thereto. I believe also that Mr. Kloppenstein has since this matter was first heard a week ago or right before the hearing, maybe the weekend before, he has taken down the shelter that he had.
The landlord's attorney emphasizes that the situation has not improved significantly. Although the defense verbally denied the allegations, no formal written response has been submitted yet. With conflicting claims on both sides, the attorney suggests that only a proper trial can resolve the dispute and determine whether eviction is justified.
Created and built essentially to allow feral cats to stay warm. And I think that has now been disassembled. Other than that, I know of no difference in the current condition or state of affairs of the home site. The very, very bright light that shines, the floodlight almost, that shines in neighbors' homes, which has caused distress to neighbors, we believe is still there. He may at this point have stopped playing the loud music perhaps as late as he had been previously. Again, that resulted in complaints from neighbors. I don't know whether he has removed the multiple bowls of cat food that was on his porch to feed the feral cats. That may or may not still be there. But again, I think we would take the position that these are items.
Things take an interesting turn when a Freedom of Information request is filed with the local police department. The landlord reveals that authorities even contacted them for additional details. This suggests that the case may involve more than just neighbor complaints. It could include documented incidents that might strengthen the landlord's position.
That the statute does not permit to be cured anyway, and that as of the date of the 30-day notice, the question is, what was the state of affairs for the home and the home site? And we believe there's sufficient grounds for termination based on the condition at that time.
Just as a matter of context, Centerville is one village in St. Joseph County. Constantine is another. They're both quite lovely little small Michigan towns. The police departments are combined in a very interesting attempt at cooperation. Centerville and Constantine have merged the two police departments under one chief. He's a retired state police officer, and he's doing an excellent job.
One of the most unusual elements of this case involves feral cats. The tenant had reportedly built a shelter to keep stray cats warm, but it has now been removed. Still, questions remain about whether feeding stations and other signs of animal activity are ongoing, raising concerns about health, safety, and community rules.
So they have the ability to share officers between both towns, use the tax base to support the department, and it's really worked quite well. So the Constantine Police Department is also the Centerville Police Department, and this complex is located in Centerville. Ms. Bauer, what's your position?
Thank you, Your Honor. First, we have an issue with the notice in this case. The notice is addressed by first-class mail to 59 Thomas Court, but none of the tenants in this park receive first-class mail at their street address. The tenants are required to get a P.O. box, and any mail directed to 59 Thomas Court would be returned as undeliverable, which we actually have.
According to the landlord, several issues may still exist, including bright lights shining into neighboring homes and loud music at odd hours. Even if some behaviors have improved, the landlord argues that the violations already crossed the legal threshold required for termination.
Some evidence to support or to demonstrate. So, from a practical matter, Mr. Kloppenstein didn't actually know that this termination was attempted until he received the summons and complaint. From a contextual matter, the termination notice says bright flashing lights, which is very different from what Mr. Landman just characterized to the court. We don't have Mr. Kloppenstein does not have any bright flashing lights and didn't understand until just now what he was being accused of with regard to that allegation. We don't have a list of any neighbors that have been disturbed by these allegations, so we certainly would ask for a list of witnesses and exhibits. The only lease violations that Mr. Kloppenstein has received.
The defense immediately attacks the validity of the eviction notice itself. They argue that it was sent to an address where tenants do not receive mail, making it effectively undeliverable. This raises a critical legal question. Can a tenant be evicted based on a notice they never properly received?
Predate the previous case. Your Honor may recall that there was a non-payment of rent case that brought the parties before the court and fairly recently, all stemming out of the park's policy of having $175 in late fees and refusing to allow anything but exact payments through their online portal payment system. We believe that this case is being brought in retaliation for Mr. Kloppenstein having defended and largely prevailed in that matter. Because again, he has not received any lease violations prior or subsequent to that date, but also he doesn't have any lease violations about his lights. He has a small radio that he listens to, but he has never been told that his radio is too loud. He doesn't have any knowledge or record of that. Also, it's a pretty small radio, so...
The defense goes further, suggesting that this entire case may be retaliation. They claim that after the tenant previously fought back against unfair fees and payment policies, the landlord responded by filing this termination case. If true, this could completely shift the narrative of the dispute.
Sure, we might have an evidentiary issue on that. Mr. Kloppenstein has requested about over a year ago an accommodation to allow one of his ESA, his emotional support animal cats, to be an indoor-outdoor cat. That cat is fixed, has been fixed the entire time. They've known about it for over a year. And he doesn't seek out or rehome other tenants' stray cats or outdoor cats. And then he denies
Well,
that
all right, you haven't filed an answer. You're testifying. So this is about the 5th time that I've been with Mr. Kloppenstein where the neighbors complain about him and feral cats. When I first heard he was living there, I asked if there were cats. He is a cat lover extraordinaire. He's used the emotional animal defense in the past.
Another key argument centers around the tenant's emotional support animal. The defense explains that at least one of the cats is legally recognized and has been approved for over a year. They deny any excessive feeding of stray animals and insist that the tenant is simply caring for his approved companion.
And in several previous tenancies, the landlord and the other tenants were aggrieved by his attraction of feral cats. I'm not sure what this structure was about, or a guy ought to be able to play a radio in his own trailer, but I'm not sure what the light is, I'm not sure what this other stuff is. This is why we need a hearing. And
Judge,
yes.
Summary proceedings rules authorize an oral answer, but I have a largely prepared written answer that I will file with the court. But we have not
I accepted that at your first appearance, but I guess you're essentially stating his position. And I don't know if there's one cat or 112.
The judge openly admits uncertainty about the situation. With conflicting stories about cats, noise, and property conditions, the judge acknowledges the need for solid evidence. Past complaints involving similar issues also raise concerns, making it clear that this is not the first time such allegations have surfaced.
What the circumstance is, I don't know about the bright light. I don't know about the noise.
So for that reason, Judge, we'd ask, that's part of why I have asked for a witness, maybe perhaps a court deadline for witness list and exhibit list filings. And the last thing I was going to say a second ago is that we have not received a timeline on our request from the Constantine Centerville Police Department, which was not a subpoena. It was just a Freedom of Information Act request, so we have no obligation to disclose that to the other side. But we'd ask for a little bit of time here because I don't know how long it will take the department to process that request. We have paid for it. So.
All right. We did struggle, and he had some legitimate defenses in there. Some of the things that the park was doing, the way you had to pay your bill and the very high late fees and some other things, we had to work through all that.
Attention then shifts to rent payments. The judge wants to ensure that the tenant stays current on rent during the legal process. A breakdown reveals multiple charges, including lot rent, home payments, and additional fees, bringing the total close to $600 per month.
And it was a payment of rent case, and he always was willing to pay his rent. He just didn't agree with the amount. So I'm going to need an escrow order here. I don't want to get him sideways on his rent. What is current rent?
I don't have the figures from the last case in front of me.
The manager,
I'll have to defer.
Yeshua, was here with us last time. She's not. What do you know what the current rent is, Mr. Senzo?
Yes, Your Honor. Let me just verify before I misspeak.
And Judge, while Ms. DeCenzo is pulling that information and I'm trying to pull up my records, I'll indicate that this is a situation where there's a lot rent and then a home purchase agreement that is paid. So we have a couple of different figures here.
And let me ask this, are you representing, I don't think I got an extra, here's the
No.
appearance.
Ms.
Are
Anderson,
you representing just Mr. Kloppenstein? You're not representing Gretchen
Correct.
Anderson?
The court carefully reviews each component of the rent, from base charges to water usage and administrative fees. This detailed breakdown highlights the financial pressure on the tenant and reinforces the importance of keeping payments consistent while the case continues.
correct, Your Honor. Ms. Anderson does not live at the property. They've not filed a supplemental complaint. And I've never spoken with her, so no.
All right.
She is a signator on the lease, Your Honor.
Yes. Well, theoretically, she's subject to default on a termination of tenancy so that she couldn't live there if she wanted to, but I think we don't really need that. At least not at this point. But I do need to know what the rent is and then what the payment is.
Do you want the breakdown or just the total amount, Your Honor?
Give me the breakdown.
Okay, so his home purchase payment is $95. Lot rent is $440. And then there are additional fees at $21.50.
The judge reads the official eviction notice, listing a series of alleged violations. These include loud noise, bright lights, poor maintenance, exposed cords, and feeding stray animals. Hearing these claims in full adds weight to the landlord's case and underscores the seriousness of the accusations.
What are those other fees? Water fee and that sort of thing?
So no, the water is a separate charge and it's based on consumption. I would say on average, he's around $42 to $43 for water.
And does he pay that to the park or he pays
Yes.
that to?
Yes, sir, to the park.
All right, $42 for water. What's the $21.50?
So $8.50 is for the meter, the metering system to read consumption. Then we have our administrative fee for $5, a mobile home tax fee for $3, and a maintenance fee at $5.
All right. Let's add all that up. 95 plus 440.
With no resolution in sight, the court moves toward trial preparation. Both sides are given deadlines to submit witness lists and evidence. Scheduling becomes complicated due to busy calendars, but eventually, a trial date is set, signaling that the final decision will come through a full hearing.